Good evening, everybody. My name is Vidya Pappachan. I'm a vice president with the South Asian Bar Association of New York, and I welcome you all for joining us for today's panel. This panel is sponsored by the Public Interest Committee. The chair of the Public Interest Committee is Rabia Kasim. She'll be help coordinating, and along with Ms. Kasim, we have a diverse group of panelists here who are here to discuss all of the developments in bail reform. It's a fairly hot topic. It's been in the news a lot, and so I know many of you are attorneys, and there's a lot of non-attorneys out there, and we appreciate you for joining us. So there is a Q&A feature as well as a chat feature, so please feel free to ask any questions as you hear from the panelists and listen to them speak. They'll be happy to answer your questions. I'll certainly ask them as we can coordinate, but there will also be an opportunity for you to ask questions at the end of this. So without further ado, I'd like to introduce to you our panel of experts. They come from a very diverse range of industries, but they are certainly experts more than I could ever teach anyone about. I am, by way of background, I do practice criminal law. I currently am a court attorney in New York City Criminal Court for the Honorable Josh Hanshaft, and prior to that, I was a public defender for 10 years. I could talk probably for the next hour about each of you, but I'll try and be brief so that we can get into the discussion tonight. The first panelist we have Judge Conviser, Judge Daniel Conviser. Judge Conviser has served as an acting New York State Supreme Court Justice since June of 2007 and sits in the criminal term of the Manhattan Supreme Court. He is the chair of the Office of Court Administration's Criminal Law Advisory Committee. Justice Conviser is the author of the Bail Bench Book, a summary and analysis of the bail reform law used by judges and court staff. He frequently lectures to judges and court staff on bail issues. We're also joined here tonight by Hemangi Pai. Hemangi Pai has been a public defender at Brooklyn Defender Services for nearly a decade. She is currently a senior trial attorney in the Homicide Serious Crimes Unit, and prior to that was a senior trial attorney with the Brooklyn Adolescent Representation Team at BDS, where she exclusively represented youth, ages 14 to 24, charged with serious felonies. She's also an adjunct professor at the Borough of Manhattan Community College. Next, we have Nitin Savur. Nitin Savur is an executive assistant district attorney for strategic initiatives. He is also the deputy chief of the trial division in charge of criminal court, where he oversees New York County Criminal Court and the approximately 35,000 misdemeanor and violation cases that pass through the court each year. Mr. Savur joined the Manhattan District Attorney's Office in 1999 and has over the years received numerous accolades for his leadership as an outstanding assistant district attorney. We're also joined tonight by Marvin Mayfield. Marvin Mayfield is a lifelong New Yorker and an avid community advocate. Marvin has been directly impacted by what he describes as the criminal injustice system, which affords him a unique and inside perspective of pretrial jailing and mass incarceration. Marvin has worked as an advocate for the Fortune Society, Just Leadership USA, and is currently a New York statewide organizer for the Center for Community Alternatives, where he continues to fight for legislation that creates a fairer, safer, and equitable society. And lastly, but certainly not least, we have Insha Rahman. Insha serves as the Director of Strategy and New Initiatives of the Vera Institute of Justice, where she helps to incubate new work in the areas of prosecutorial reform, bail, and decarceration. Insha is also a former public defender and a nationally recognized expert on bail reform. She has drafted bail legislation and policies across the country, including recently passed reforms in New York State. She serves as a board member for the New York Civil Liberties Union, the Brooklyn Community Bail Fund, and the Indigent Defense Organization Oversight Committee of the First Department. And so I want to, as we get into the subject matter of tonight's discussion, I know that many of you are probably aware that 2020 has really been a hot topic for bail reform. In January of 2020, the legislature passed some sweeping bail reform laws that really changed the structure of what bail was over the last several decades. And then within months, in April, those changes were, in a sense, adjusted and rolled back. But I think arguably the core of what bail reform has remained the same. But I think before we get into what has happened in 2020, Judge Conviser, you're an expert on the law and dealing with this, and on the advisory committee, I think I'd like you to provide the attendees a little bit of background as to what the framework of bail really is and what the purpose of bail is and pretrial detention.
Sure. Good evening, everyone. It's great to, I don't see you. I wish I could see you, but it's nice to be with you today. So I know we have people with lots of different degrees of knowledge. So let me start with sort of the basics. When someone is first arrested, the court has to set what we call a securing order. And a securing order means the type of restriction, if any, that we're going to be imposing on the defendant throughout the course of the criminal case, because we want the defendant to be coming back to court. And when you start to think about a securing order, in other words, an order that we're going to issue with respect to the defendant, there are three possible things a securing order could do. In any kind of system, a securing order is designed to ensure that the defendant comes back to court. Because on the first day that the defendant is seen in court at their arraignment, unless the case is dismissed or there's a plea at arraignment, the defendant will have to come back to court, sometimes many times, sometimes over a period of 6 months or a year or longer. And so first and foremost, we want to set an order that ensures the defendant will come back to court. The other two possible things you can do with a securing order are to protect public safety, which in New York is not an explicit purpose of a securing order. And we're going to get into that discussion as we go along, and potentially also to help a defendant by forcing or directing the defendant to engage in rehabilitation, which again is not an explicit purpose of securing orders under New York law. And there are basically four things you can do in general categories. First, in a securing order, you can release the defendant on their own recognizance, meaning that we direct the defendant to come back to court on the ensuing court dates, without any kind of restriction on their liberty, other than the fact that we're directing them to come back to court. And if they don't come back to court, there are things we can certainly do as judges. We can issue a warrant for their arrest. We can set bail on them later. We can incarcerate them if they return, and so on. So that's the first thing. The second thing we can do is to impose what are called non-monetary conditions of release, which could mean being in contact with the pretrial services agency to help ensure that you're going to come back to court. The third thing is to set some form of monetary bail. And at that point, the defendant either will be released upon the payment of the monetary bail or the pledge of the monetary bail, or they will be incarcerated because they cannot meet their monetary bail requirement. And the final thing is to remand the defendant to custody during the course of the case until the case is resolved. Now, bail reform was enacted in April of last year, in 2019, and became effective initially on January 1st of this year. Then the legislature walked back the bail reform in April of this year, and those walkbacks became effective on July 2nd, just a few weeks ago. And in a nutshell, although judges over time had been setting bail and incarcerating defendants pretrial to a lesser degree, the legislature and the governor certainly believed that judges needed to be further restricted in their ability to set bail and remand defendants, because the view was that too many people were being incarcerated pretrial for no good reason. That monetary bail certainly is highly dependent on how much money you have. And as a basic principle, we don't want people to be incarcerated because they don't have money. And obviously the monetary bail system, by hinging your liberty on your ability to afford bail, can have a tendency to incarcerate people solely because they don't have enough financial resources. And bail reform was also galvanized, I think, by one particular case. The legislature often reacts to particular cases. They did that when they retrenched the system this year. And they initially did it in part on a famous case of a young man named Khalif Browder, who just shy of turning 17 was arrested for allegedly stealing a backpack, had bail of $3,000 set, wasn't able to post it, ended up being in jail for 3 years. And upon being released from jail later, took his own life tragically. And that sort of became a symbol of everything that was wrong with the bail system. And like any individual case, it revealed a lot and also was atypical in a lot of respects, because it certainly was a more extreme case than you would usually have. But the perception of the legislature and the governor was that the discretion of judges to set bail and remand defendants pre-trial had to be restricted. And so they restricted it in a very significant way. And that's one of the things we're going to be talking about.
Thank you, Judge. And, now that we kind of understand the law, Nitin and Hemangi, you both as practicing assisting district attorneys and defense attorneys, you're really more involved in the day-to-day core activities. So hearing what the purpose of bail is and knowing what the purpose of bail, how does that translate to how matters are actually addressed in the courthouse? Nitin, as a district attorney, it's your assistants that are really arguing for bail or for a certain amount of bail. And so how do you think that underlying purpose sort of translates to what actually happens in the court?
Sure. And by the way, thanks for having me here tonight. If I can just go back for a second before January 1st, 2020, and go back to the Anglo-Saxon period in England from 410 to 1066. This is when bail was developed, right? And it was a means of settling disputes amicably, peacefully, right? And so that was the purpose of it. And how it worked was when a person was charged with the crime, they would ask someone in their family or they would ask someone in the community to step forward and say, if this person ultimately owes money to this victim, this family member or community member would come and pay it. So the bail was actually never turned over to the court. It was just a method of securing in case the person fled, which was usually not an issue back then. And that system was in place for hundreds and hundreds of years until you had industrialization and people start moving. And now people could flee or they can't find people in the community to represent them to the court. So that's when you had bail bondsmen coming in. And so I think in the 1900s in the United States, we saw the system change from a promise to have somebody pay if you don't show up to having an industry of other people deciding who gets to remain out of jail while their case is pending and who actually has to put up money. So now, if you look at 2020, I'm a prosecutor. What we do is we have two roles, right? Not only just ensuring public safety in our community, but we also have to make sure we safeguard the rights of the accused. Right? So when a person is arrested, those cases come to us from law enforcement. We have to look at the facts of the case. We have to draft an accusatory complaint if there's probable cause to charge this person with some crimes. And now we have to know that within 24 hours in New York, that person is going to be brought in front of a judge and to be arraigned on the charges. And we have to make a decision at that point, whether that person is going to have bail requested or that person is going to be released. And so we have to make that decision based on our current framework of law, which is this person going to return to court or not? That's the sole criteria we can look at. And when we look at that, the criminal procedure law allows us to consider like 8 different factors. And we have to look at those factors. We have to look at the charges. We have to look at the person's prior criminal history, their prior attendance in court, have they appeared or not? And then we show up in court and we make a bail application. But the whole purpose of this is to just ensure that the person returns to court, right? And that's what we do. And the judge and the defense attorney, which Hemangi will explain what she does next, and the judge ultimately has to decide whether to set bail or to release the person on their own recognizance or to release them with other conditions.
Right. And I think, it's obvious what the purpose of bail is and really what it should be theoretically. So, Hemangi, as a defense attorney representing clients, do you see that the underlying purpose of what bail is supposed to be really actually translate in the day-to-day operations in the courthouse?
So I want to say thank you for having me. I want to answer the question, yes. but unfortunately, I don't think I can. I don't see it working out the way that we think it is. I understand the purpose of bail is to ensure someone's return to court, but practically speaking, that does not always happen. And more often than not, especially when you're dealing with serious crimes, it is the nature of the charges and the facts of the case that sort of decide or give the judge what they need to decide to set bail. So I just want to explain what happens when I step into the picture. So as Nitin was mentioning, there's an accusatory instrument that's drafted and then a person is arraigned. And that arraignment is when the district attorney's office will often ask for bail. And I meet a client at arraignment. I meet the person who's accused with the crime, and I get some information from them about their contacts with their community, where they live, all of that kind of stuff. And then we get on the record in the prosecutor's office, depending on the nature of the charges, which I know we're going to get into later, what's a qualifying offense and what's not, we'll make a request that bail be set. And they'll give reasons, like Nitin mentioned, about prior contact with the system, if there had been any other failures to appear. And then typically the prosecutor will give a short recitation of the facts. And what I want to make clear is that that recitation of facts is not a complete picture. It doesn't include all of the investigatory information that's been discovered in the case, right? There's a lot of investigation that happens after a person is arrested and after a person is arraigned. Sometimes that information, and I'm not saying it because it's done with malice, but that limited information doesn't include exculpatory information, information that tends to show the accused's innocence. It doesn't include recantations. It sometimes doesn't include those things which end up leading to an outright dismissal in a case. And then there's a dollar amount that's attached, right? There's a dollar amount that's requested. And then judges make a decision based on all of those factors. And in my experience, some more often than not, that decision is made by hearing about the facts of the case and the weight of the evidence, this limited presentation, the weight of the evidence against an accused. And then judges make the decision based on their opinion, right? Based on their own implicit and sometimes explicit biases, because as we all know, judges, just like the rest of us, are human beings, and we all have implicit biases, and we all have, things that we come to the table with, that we all pay attention to stereotypes one way or another. And then decisions are made on how much bail should be set. And, in my experience, what I've learned is that the more serious the crime, the more likely a high amount of bail is going to be set. And I think that's in part because we work off the premise that the more serious a crime is, the more likely there's going to be jail time. And the more likely there's going to be jail time, the higher the stakes are, right? So we want to set some kind of bail to give someone the incentive to come back to court. Because if you're facing 10 years in jail, you might, as Nitin was saying, now that we have the opportunity to move around and things like that, you may not return to court, right? So with that premise in mind, that incentive to get somebody to return to court, you would assume that bail would be set in an amount that the person who's accused could pay. So then their family would put up that money, or they would put up that money, and then they would have every incentive to come back to court so that their family or whoever doesn't lose out on that money. But that typically is not how it happens. Even when we ask for a certain amount of bail, because when I'm meeting with the client, I get a lot of information. I reach out to their family members. I reach out to their community members to see how much bail they can afford. And then I might ask the judge, if you are going to set bail in this case, can you set it at this amount because this is what the person can make? And there are some judges that do, and there are quite a few that don't. And they'll set a much higher amount of bail. So what incentive, if we're doing it for an incentive to ask to get them to return to court, what incentive are you giving them if they can't pay, right? You're just jailing them, incarcerating them pre-trial. And what we've seen is that a lot of complaints contain charges that are overcharged, that at the end of the day, when everything falls where it does, it's overcharged. We've seen, especially in Brooklyn, we were able to work out incredible offers in cases where clients will walk away having been charged with very serious violent felonies, and then they end up walking away with, non-criminal offers, programs, things like that. But they'll sit in jail for months and months and months waiting for that. And the practical application of that, and maybe I'm jumping ahead, Vidya, so please interrupt me if you feel. But what happens to a person when bail is set is is awful, right? They're held. Sometimes they're held, like Khalif Browder was held for 3 years on $3,000 bail, right? And $3,000 to me or you might not seem like a lot. We could pool it from our families, we could get it. But for somebody who's poor, who doesn't have any means, who doesn't have a family member that they can turn to, who can't easily get a loan, who maybe is living in public housing and just literally living check to check, $3,000 is like $3 million, right? And so what happens is a person can be held for the entirety, the pendency of their case. And like Khalif Browder, his case took 3 years. In the process, they can lose their housing, they can lose their jobs, they can lose access to their children, they can lose their benefits, they can lose any credits that they have for school if they're young. And what we've seen is that they're more likely to end up taking a plea to, and not necessarily to the top charge, but taking a plea that could give them a criminal record, right, for the rest of their lives. And one thing I think we tend to forget is that it is very difficult. As a defense attorney, I can speak to this very clearly. It is very difficult to help somebody properly prepare a defense when they're incarcerated. They're not able to participate regularly in the investigation in their case. Let's say I have a pressing piece of information that I need to talk to my client about and they're incarcerated. There are times when it takes 2-3 weeks for me to be able to see my client, especially now in the pandemic, where we're only able to see clients through Skype and we're only able to see them Monday through Friday from 9 to 5. And that's the same time period and the same Skype booths that are being used across the city to do preliminary hearings, to do court appearances. I can't even tell you the number of cases that or the number of appointments, video conferences that I've had that have been rescheduled because there's a court date that takes precedent. So it impacts the ability to help in your defense. It impacts my ability to create a relationship, a meaningful relationship with my client. Cases are not just you did this and you did it for this reason, so you need to go to jail. There's just so much more nuance, so much more complicated information and just so much more to what happens in each case. And that requires a level of trust building on the part of the defense attorney with your client. And how are you supposed to do that when you're talking to them through a computer once every 3 weeks, or when court was actually in session, when you're meeting with them on their court date because you can't get out to Rikers because you're in court all day, or you can't get them in for a video or on a video conference for weeks, or you can't have them produce. And then finally, then I promise I'll stop talking for a while, all of this really cuts against our presumption of innocence, because what it really boils down to is that an assumption is being made that the person who's standing in front of you when that first request is made for bail, that they have committed the crime that they're being charged with. And what we found is that when you're incarcerated, there's a level, it perpetuates perpetuates the fact that an accused now needs to prove their innocence to be able to get out of jail. And that cuts against one of the most fundamental principles of our country, which is the presumption of innocence. So I think while I really would love to say that it plays out in the way that it's supposed to, in my experience, it does not. And it really negatively impacts Black and brown people, because Black and brown people are the most over-policed, and they are the ones who are prosecuted at much higher rates. And the numbers, and I think we're going to get into this later, and I'm sure Insha and everyone else has the statistics on this, but the numbers in other counties outside of New York City are just outrageous, and the racial disparity is outrageous. So thank you for letting me.
No, I appreciate that, Hemangi. And, I do want to circle back to you, Nitin, but I see you, Marvin, nodding your head a lot. And you bring certainly a very unique perspective to this. Not only are you, as part of your position, do you advocate and you really know the ins and outs of how laws are sort of passed and advocating for that, but you also you represent sort of the community, and you have a personal perspective because you really were directly impacted by what bail really is. So could you just speak to that a little bit?
Sure, I'd be happy to. And I just want to thank for the opportunity to be here today in this distinguished panel. And I can echo quite a bit of what Hemangi just said. And I think it would be a disservice if I didn't keep it up front that I am formerly incarcerated and that I have been directly impacted by the draconian bail laws that have been a problem for people of color and Black people in my community for ages. And if you don't mind, I'll just tell you a little bit about my story and how it relates to me. I was a younger man then, but I was picked up by the police. I was beaten up by the police. I was a suspect in a burglary. I was tossed in a holding cell and swollen and bruised and left to sleep painfully on a steel slab until the morning when they transferred me to central booking. So for the next 48 hours, I was shuffled around from cage to cage before ever being brought before a judge. When I did see a judge, he imposed a $10,000 bail. I think it's important to mention that from the beginning of my ordeal, going through central booking and the precincts and everything, there were a number of white men at arraignment as well. Now, there were only Black and brown men being chained and shackled and loaded onto the buses. I had heard about it, but nothing could prepare you for the noise, the filth, the smell of Rikers Island. I was only in a holding cell of the receiving room for a few minutes when I was confronted for my coat and my sneakers. And that was my first assault. Nobody came to my rescue, no guard, no supervisor, and nobody even cared or seemed to notice that I was barefoot. So for another 2 days of being shuffled around from cage to cage because of the overcrowding at the time, I was finally assigned to a housing unit where I could get a shower and get a bed. I was exhausted. And when I got there, I was confronted again by, guys who were in jail. And they asked me if I had any cigarettes or any weed. I had any money on me. With my coat and my shoes already gone, I had nothing of value. So this time they decided to take my dignity. I was assaulted again, and this time my leg was broken. Over the next 11 months, I was beaten, I was chained, strip searched. I had to suffer and endure these indignities, not because I was guilty, not because I deserved it or because I was in a gang, but simply because I didn't have the money to pay my way out of jail. So for 11 months, out of 11 months, I went to court 22 times, sometimes 2 and 3 times in the same week, and often saw no one. But the worst indignity out of all of this is that after 11 months, trying to fight my innocence, I was coerced into taking a plea bargain just to end the suffering. So, as Hemangi said, disproportionately, it's Black and brown people who are the commodity in the prison industrial complex in America. Human beings are being kept in cages day after day and month after month and year after year because they can't afford to pay their way out of jail. This is the problem with the monetary bail system. I ask you, what kind of justice is it when only those who can afford to pay their bail are released and allowed to answer their charges as a free person with liberty and dignity? Everybody. I know there are a lot of attorneys, legal professionals on this call. But for those of you who don't see it every day, who are not a judge, who are not a district attorney or a public defender, who don't know, I want you to understand that everybody needs to understand that these are not numbers and these are not statistics. These are people, our brothers and sisters, mothers and fathers, our sons and daughters that are being held as prisoners in a system that is fundamentally racist and socioeconomically prejudiced against people of color. And this system of oppression, it never stops. It's one thing after another, one system of oppression after another. It's been slavery, Jim Crow, voting rights, civil rights, and today we're faced with this culture of mass incarceration, which is largely fueled by a cash bail system. It took decades. It took a lot of hard-fought advocacy to bring some meaningful changes to New York's unjust and inequitable racist system of pretrial detention. The bail reform that was passed last year, passed in the 2019 legislative session, represented a historic step forward for pretrial justice across the state. The changes that were made, some people refer to as tweaks. These are not little tweaks. These are devastating rollbacks that will expose tens of thousands more New Yorkers, overwhelmingly Black and brown and poor people, to jail. More and more each year. So that is my story. I hope that someone's been enlightened by what I said today. Thank you. Vidya, back to you.
Marvin, thank you. I'm so saddened to hear about your experience, and I think anyone listening to what you went through, it's heartbreaking, and most people can't relate. So your perspective is certainly, it's important, it's eye-opening, and it sort of provides, just an outside of the legal perspective as to what bail really is about. Insha, you have been both a practicing attorney, you were previously a public defender, and you are nationally recognized in terms of your expertise with bail. And I know you've worked with Judge Conviser, you worked with Nitin here in terms of evaluating the purpose of bail from a very holistic perspective. And I want to sort of transition now into bail reform and the leading up to bail reform. And so do you believe that cash bail should be eliminated in all circumstances? The other side of the argument is nobody wishes what Marvin went through upon even their worst enemies. But on the other hand, as a district attorney, there is an argument to be made that the interest of victims should also be respected and recognized, and the prevention of crime. So is cash bail, do you think, necessary in some situations?
So one of the things that doesn't get said nearly enough about cash bail, we certainly talk about its the harm and the impact it has on Black and brown people who, because of generational inequity and poverty, can't make bail. The Federal Reserve did a study 2 years ago that found that over 40% of Americans actually don't have $400 to cover an emergency. The average bail across the country on a felony case is $10,000. So you can just imagine the gap in terms of being able to afford it. But even put that aside, we tend to sort of say money bail actually incentivizes people to come back to court. But what we know is that money bail, for one thing, is actually a fairly uniquely American function. There are many countries in the world that have a pretrial system where money is no part of it at all. And even above and beyond that, we are an outlier in having a for-profit money bail system, and that we allow for bail bondsmen, private interests to make a profit off of somebody being arrested and bail being set. And in all of that, being an outlier and using money bail, and especially an outlier in allowing for profit to be turned off of the bail system, what we also know is money bail actually doesn't get people to come back to court. If you look at the statistics, people who are just released on their own recognizance, so literally released with just a promise to return to court, they come back. Here in New York City, we know 87% of people who are released on their own recognizance just come back to court. The most effective way to get people back to court is actually not money bail. It's actually a reminder of the court date, right? Much in the way that my dentist texts me to remind me of when my next dentist appointment is. We've seen that literally just reminding people, here's their next court date, makes people show up. In addition to that, we know that providing things like transportation, because it costs money to get to court, or providing childcare, or allowing for people to have flexibility in when their court date is, all of those things actually incentivize people to come to court because it's easier, it works to come back. So no, we don't need money bail. It's a construct that we have inherited from English law. It's one that is just sort of part of the fabric of the American legal system. And it's one that, its time has come to jettison it. And there are places in the country that got rid of money bail well before we did. Washington, D.C. has not relied on money bail at all since the early 1990s. Our neighbors, New Jersey, enacted bail reform back in 2017. They essentially eliminated money bail. And what they found is court appearance rates remained the same. And in fact, crime declined, even though there were far fewer people behind bars. Here in New York, what we know is New York City, and Judge Conviser mentioned this, judges had started to rely less on money bail even before bail reform was enacted. And court appearance rates remain the same. And New York City has historically been at an all-time low in terms of crime. We are literally the safest big city in this country. And we've done that all while relying on incarceration less. But at the same time, when we did set bail, it was often on Black and brown people. And certainly it was for people charged with serious offenses, but it was also for people who were charged on low-level offenses. And who did that impact the most? That impacted Black and brown New Yorkers. Literally, if you look at who is behind bars, it is in not only in New York City, where it's 87% of folks at Rikers, but across upstate New York, even very predominantly white counties, their jails were full of people who are Black and brown. And so bail reform, when it went into effect, what we saw is literally our jails opened up and emptied. We have half as many people in jail across New York State today as we did this time last year. We literally went from having 21,000 people behind bars this time last year when bail reform was passed, to now we have a little over 9,500 people. That's a remarkable difference. And here's what we also know is, not only in New York City, but across the rest of the state, we are as safe as we have ever been. I know we're all seeing reports recently of an uptick in violence and gun violence and crime. But actually, if we compare it to where we were 5 years ago in this city, it's the exact same numbers. And the real difference now is we are on the heels of a pandemic, of mass death, of mass unemployment, of mass instability in our lives. If there is, in fact, an uptick, and it's a sustained uptick in crime and concerns about violence, really that's the thing to blame it on, not bail reform, not changes that are, needed and long overdue in our criminal justice system.
No, Insha, you raise a great point, because I think that is the crux of recent criticism in terms of, whether bail reform is really working. I think it's important we talk about this abstract idea of bail reform. And Judge, I want you to get into what bail reform really was. But Nitin, if I could just briefly ask you, as the system stood before January of 2020, did you feel like there needed to be changes with the way the bail system was set up, or did it really adequately serve its purpose? And these are sort of outliers situations that we're discussing.
We absolutely needed bail reform in New York, right? Absolutely. The DA that I worked for, Cyrus Vance, he took office in 2010, and he came in when criminal court had 100,000 cases, right? It was such an overburdened court. Last year, we had 33,000 cases. We have reduced criminal court by about 60%. And this year, we'll probably be in the 20 range. But when he came in, he focused on two things. He said, I'm going to focus on public safety, which is keeping our streets safe, and also fairness in the courts, fairness for everyone who's in the court, including the person who's charged with the crime. So one of the first things he did was he spoke to the Vera Institute, and they had approached him and they said, would you be willing to do a racial disparity study in your office, looking to see if disparities exist? And at the time, not that many prosecutors in the country were willing to open their books, allow a third party to come in, to look at what's happening and actually publicly report it. But he said, I'm going to do this. I'm going to do this because I want to be a leader in this area, and I think it'll encourage other people to do this. He also said, if I'm concentrating on fairness in the courts, how can I not try to identify where the problems were? So we did a 2-year study with Vera. They actually moved in. We gave them a data set of about 222,000 cases, and they looked at different areas, the cases we were taking in, the cases that we were dismissing, the cases that we were asking for bail on, our offers, our sentences, and it was not a surprise that they found that disparities existed in all these different areas. So if we're talking about bail, I think the Vera study showed that there was about, blacks were 10% more likely to be detained than similarly situated whites. Latinos were 3% more likely to be detained by someone who's white who has the same criminal background. Asians were actually 21% less likely to be detained than similarly situated whites. So we saw across the board, there are disparities in our criminal justice system. A lot of these are implicit biases, right? No one comes into work and says, I want to treat someone differently than someone else. But these things do happen and they creep in. So we've been focusing ever since that the report came out in 2014, but we started getting the results in 2013. We've been focusing on different areas in our office. A lot of them were based on Vera's recommendations on how do we reduce those disparities across the board, including in detention, right? So yes, we're all in favor of bail reform. We think that the construct that was in place before 2020 was not a good one, that only looked at a person's, or whether they're going to appear or not. We think that if you look at other jurisdictions, they have much more robust bail, standards. And that's what we've always been waiting for and hoping that would eventually pass.
No, that's very enlightening, eye-opening to hear, because it appears that, everybody is on the same page, that change really was necessary. And how we go about that change, it's a daunting prospect in terms of how that change really needs to be implemented in an effective way. Judge, I'd like you to just explain to our listeners and to our viewers, really, so we talk about bail reform and all of this stuff, but what does reform really mean substantively in the law? There were changes in January, and then there were changes that were put into effect in July 2nd of this year. And they really were highlighted and really were quite different changes. And so as to the system that existed for decades prior to that. So if you could just explain that a little bit.
Yeah, and I'm just bursting to say a bunch of things when hearing everybody talk too. And I just want to make a couple of brief points, because I think everyone that I've heard has made excellent points, but a couple of things I wanted to just say. Number one is, if you look at the change in the New York City jail population from the height of the early 1990s to today, it's dramatically lower. And that has to do with a few things. One is the reduced crime rate, first and foremost. The second is the reduced tendency of judges to impose securing orders that resulted in pretrial incarceration prior to bail reform. So as society had changed its view about pretrial incarceration, judges were also changing how they behaved. Then you had bail reform, and now you have COVID. And when you add all those things together, bail reform is a part of it, but it's only one part of what has been a dramatic decline in the jail population. I think it's about a 70 or 80% decline from its high in the beginning of the 1990s. So this reform tendency has been done, by reduced crime, by judges' behavior, by bail reform, now by the emergency of COVID. The second thing that I always think about a lot when I think about bail reform, and I think it's very interesting, is that all of the participants in the system, by which I mean the prosecutor, the judge, and even the defense lawyer, to some extent, I'll explain why, have incentives that may push them towards pretrial incarceration. Now, that doesn't mean that actors are behaving to incarcerate people for no reason, but when I talk about incentives, if you think about, for example, the prosecutor, right? And then the Manhattan DA's office that I work with, they're an excellent office. They're full of very smart, ethical people. But from a prosecutor's perspective, a defendant incarcerated makes it easier to get a plea bargain. It makes it easier to resolve the case. That's just a fact. If you have a judge, if the defendant is incarcerated, the defendant's coming back to court. The defendant is not going to go out and commit a heinous crime. That's a fact, right? If the defendant is at liberty, there's a risk that those things may happen. And even defense lawyers may have difficulty convincing a client to take a favorable plea bargain if the defendant's at liberty. So there's a lot of incentives that sort of push all of us unconsciously, I think, towards pretrial incarceration. But getting to the reform did a few things. One is it created certain crimes for which the courts could not initially set monetary bail or remand, which were called non-qualifying offenses. So it divided up the penal law. The penal law has, I think, thousands of distinct crimes. And it went through the penal law section by section, subdivision by subdivision, and picked out certain crimes for which you could impose bail or remand initially, and then certain crimes for which you could not. And in the category of crimes for which you could impose bail or remand initially were things like violent crimes and sex crimes. In the category of crimes which you could not initially impose bail or remand would be things like almost all narcotics crimes or theft crimes. And the problem with the reform, from my perspective, I mean, first of all, from my perspective, and I'd love to hear what everybody thinks about the New Jersey model, because to me, that's really what we should be doing. We should be going to a system where you don't have monetary bail at all, and you either have release with conditions, or remand. But the New Jersey model ends up remanding a fair number of people. I mean, there are people in jail pre-trial under the New Jersey model, not because they can't afford bail, but because they're considered too great a flight risk to allow to be released. But in any event, that's the model that I would prefer personally. But the reason that the initial reform and the sort of retrenchment of the reform doesn't make sense to a lot of judges is this. When we set securing orders and we try to decide what type of securing order we need to ensure a defendant's going to return to court, we think about many different things. We think about the charge. We think about the strength of the people's case. We think about the community ties of the defendant. In other words, is this a defendant who committed a crime when they were here for the weekend from Virginia, or are they somebody that's lived in the neighborhood for the last 30 years? We consider their criminal history. We consider their prior history of failing to appear in court as directed or failing to abide by court orders. And what the bail reform statute did is it said, when we make our initial decision, are we allowed to set bail or not? We're going to make up this list of crimes. And based on that one factor alone, that's going to tell us whether we have the discretion to set bail or to remand. And that doesn't make a great deal of policy sense to us, because it's not the only thing we think about. In other words, if you went to a doctor and the doctor was trying to decide whether to do some intervention that was going to be very harmful to you potentially, and the doctor was going to look at 8 or 10 factors to make a decision, you wouldn't say, well, I'm going to only look at one factor. I'm not going to look at all the factors. So that's why the reform in a lot of ways didn't make a lot of sense to a lot of us, because it set up these arbitrary rules. And also, one of the interesting things about bail reform is when you look at the crimes that the legislature chose to prohibit bail for versus the crimes that they allowed bail for. And I'm talking about now the original bail reform law that took effect in January. You can't understand it only in terms of flight risk. You have to understand it as well as an implicit attempt to look at public safety risks, because there's no other way to make sense of it. So let me give you this example. Under the original bail reform law, if you stood charged with the Class B misdemeanor of sexual abuse in the third degree, which is punishable by a maximum sentence of 90 days in jail, the court is allowed to set bail. I could theoretically set bail of $10 million if I wanted to. Not that I would do that for that kind of low-level misdemeanor, but I could. Now, on the other hand, if I had a defendant who was charged with a Class A1 felony drug offense involving kilos of heroin, who had a prior violent felony and was facing a determinate sentence of up to 30 years, I could not impose $1 of bail. Now, how can you possibly explain that? You can't explain it by looking at flight risks. You can only explain it by looking at imminent public safety risks, by considering the fact that this alleged sex offender, might go out and commit another sex crime, when the offender walks out of the courthouse, whereas the drug offender with the kilos of heroin may be responsible for a lot more mayhem, but won't be doing it, when they walk out of the door, that afternoon. And so to us, the initial reform was flawed in its basic premise. The initial reform also did some other things. One thing I think it did that I think was great and terrific is it set up what we call the least restrictive alternative rule. And what that means is that when we look at a defendant, what we're required to do under the bail reform law is to start with the presumption that defendants should be released on their own recognizance. That's step one. That's step one for a misdemeanor. It's step one for a defendant charged with murder. Now, that doesn't mean that we're going to be releasing defendants charged with murder without any bail, but it means that you start off the thought process by looking at the presumption of release on recognizance. Only if that is something that won't reasonably assure the defendant returns to court do you start going up the levels. Do you start looking at non-monetary conditions, bail or remand? So that principle, I think, is fundamentally important. And it's a principle that I think we all as judges try to abide by. The reform also expanded the use of non-monetary conditions and pretrial services agencies, which, as Insha said, is a very effective way of getting defendants to come back to court. Just being in contact and reminding a defendant to come back to court is very effective. So it set up a whole system of non-monetary condition agencies, and I think that was a very good thing. It changed the way a monetary bill works. So in every case now, we have to consider setting what's called an unsecured or a partially secured surety bond. And what that means is that instead of just having a bail bond company set a bail bond, which is what judges typically did before, now in every case, we have to set up a bail. If we're setting a monetary bail requirement, we have to allow a defendant to have a friend, a family member, a coworker, an acquaintance pledge the amount of bail and put up some small portion to the court, up to 10%. And so I think that was a very good reform. So that's the legislation.
As you go on and explaining the law, I want to circle back a little bit because, one of the things you talked about when you first started the conversation was qualifying offenses. And it's turned into this sort of formulaic system in which bail has been evaluated. So just going back to qualifying offenses, part of that criticism, though, is that judicial discretion has now been removed. And, well, does it somehow compromise the role of the judges? And so do you think that criticism is really in line with bail reform? And also, is it necessarily a bad thing?
Well, look, I think I agree with everybody here that we as judges needed our discretion to be limited, because I think we were setting bail too often in too many cases where defendants were incarcerated when it wasn't necessary. So I think the principle of restriction was a good one. I don't agree with the way it was done because, as I said, the charge is just one of many things that are relevant to flight risk. And, beyond just the general principle and beyond the fact that some of these distinctions don't really make sense in terms of flight risks is when you look at what the law actually says, so one subdivision of a statute will be a qualifying offense, another one won't be, although it's sort of the same or a similar crime. So it's these distinctions that were made, in the negotiation process between the two houses of the governor. And so it has the effect of eliminating discretion to set bail or remand in many cases. And if you want to eliminate the discretion to set bail or remand, that's a good thing, right? If you want to say that judges should never be able to set bail for a narcotics case, then that's a good thing. But by the way, when you look at this, for example, let's say I have a defendant who's charged with a low-level felony, right? But he's been convicted 80 times of misdemeanors. I've had cases like this many times, right? He's got many, many bench warrants. I don't think this defendant's coming back to court unless I set some kind of securing order, right? Now, I'm not allowed to do that. And you may say that's fine. We shouldn't be able to do that. Under the original bail reform law, even significant quantities of narcotics were not eligible for bail. Someone that stole $100 million, I could not set $1 of bail on under the original law. That's different now under the amendments. But, a lot of these things to us didn't really connect with flight risks. And again, maybe I'm just, wishing for something that's not going to happen anytime soon. I think the best way to do this would have been just to eliminate monetary bail and go to a New Jersey system, but we didn't do that. And so we're left with this qualifying offense rule, which has, on the positive side, it has resulted in a lot less people being incarcerated. So if that's the goal, it served that goal. Certainly.
Can I add something here?
Oh, sure. Go ahead, please.
I totally agree with what the judge is saying about this qualifying offense rule. And I think it restricts the judge's discretion. I don't know if you know this, but the original reforms, we went from a system where you could ask for bail on any misdemeanor you wanted, or a violation even, which was too much, right? And you needed a reform, to a system where you can only ask for bail on 5 qualifying misdemeanors. That's what the January 1st, 2020 reforms were. 5 qualifying misdemeanors, 4 of which were sex crimes, and 1 was a domestic violence. So there are a lot of crimes out there, like assaulting someone, stalking someone, menacing someone, right? Violating an order of protection in a non-domestic violence case, where the judges had no discretion whatsoever to set bail. So I think that on one hand, you do want to limit the discretion. You want to reduce racial disparities, but this kind of took away the judge's discretion altogether by just having two buckets of qualifying and non-qualifying offenses. Right? I'm actually much more in favor, like what the judge said, in a model like New Jersey, which just eliminates cash bail altogether, and it just keeps people in if they are violent or dangerous or a threat to public safety or are not going to show up in court. But everyone else gets released and you don't have any cash bail.
Right. Insha and Hemangi, I see that you both have...
I can't wait to jump in. This is maybe one of my favorite conversations, which is what works in New Jersey's bail reform and what I think, frankly, doesn't. So New Jersey in 2017, and mind you, New Jersey, before their new bail reform went into effect, had a bail system that was similar to what ours was before bail reform. The only thing that judges could consider, at least in theory, was court appearance and failure to appear, flight risk, not threat to public safety or risk to public safety. Once New Jersey enacted bail reform, they essentially jettisoned money bail, and judges have the decision to either detain somebody or release someone. And what New Jersey found is judges certainly started releasing people more. The jail population overall declined by about 30%. But what didn't move at all in terms of the jail population was the racial disparities and the fact that as many Black and brown people remained in jail pre-trial in New Jersey after bail reform, as was true under a money bail system. And so we actually looked at the data to figure out why is that. And here's what we found is that on serious charges, so the charges that are equivalent to the qualifying offenses where judges can still set bail in New York, judges were detaining people in New Jersey on those charges. But what we saw is on low-level offenses, the offenses that are the equivalent of the non-qualifying offenses in New York, the cases where people just are released, there is no option in New York to detain people anymore under the new law. Those were the cases in New Jersey where judges were still detaining people, but predominantly Black and brown people in New Jersey on low-level offenses. And so when you leave in discretion, especially on low-level offenses, what we have seen, and this is true in New Jersey, this is true if you look at bail data and the use of pretrial detention across the country, bail gets set more often or pretrial detention gets imposed more often, all other things being equal, on low-level offenses when the individual is Black or brown versus white. And so that's why I fundamentally have a problem with the New Jersey model, because if you retain discretion to take away somebody's liberty on a low-level offense, and Judge, I recognize what you're saying about, well, somebody has a prior history of not coming back to court or several past convictions. Well, it's not like the only option is just to release them. You can release that person now under the new law with conditions of monitoring and supervision. And what we know, and ADA Savur, your office really piloted and launched the program of supervised release and paid for it to be expanded across New York City. The vast majority of folks who were going into the supervised release program, which was released without any bail being set, but some conditions of supervision and supports, found that these are people who were considered, sort of high risk of failure to appear, and yet they were coming back to court when they had the supervision and supports of pretrial services. So, we know this, when people are charged with relatively low-level offenses and we have concerns about whether they'll show up to court, that's what pretrial services is for. It's not what bail is for. And that is both, I think, a moral judgment as well as one that we should look at the data across the country and our neighbors in New Jersey. And it was really that inspired the legislature to say, okay, for this number of offenses, and mind you, most arrests in New York City and across New York State are for misdemeanors. In New York City, 83% of all cases arraigned are misdemeanor cases. Across New York State, it's a little bit more like 75%. So we're talking about the vast majority of cases that come through the system. People are charged with low-level offenses. It's basically a moral judgment that those are folks who should be released. The discretion, though, is around what conditions are needed to support that person and to make sure that they show up in court.
So, given that you've studied bail systems in different places, how would you design the system?
So this is also a great question, because we at the Vera Institute of Justice, and I was involved very closely in drafting and passing bail reform here in New York, what we had actually advocated for in 2019 was a system that was somewhat similar to what you were advocating for, Judge, and what I know that you would have preferred, which is eliminate money bail entirely, have mandatory release for the vast majority of offenses, and then for a very small number of violent felonies, other offenses where we actually have concerns about the public safety or a person's safety, we have a very limited and narrow standard of what consists of public safety. And that, for me, would be that there is a hearing, a fact-finding, to actually see, does this person pose a physical danger or threat to another person? And if that is true, and if there are no conditions for that person's release that can make sure that that other person that we're concerned about their safety can be safe, that is when you impose pretrial detention. That's not the law that passed. The law that passed was, we're not going to consider public safety or dangerousness explicitly. And there are lots of good reasons why, and I can argue both sides of this. I think reasonable minds can disagree about whether dangerousness is an appropriate standard or not, because in this country, what is considered dangerous and criminal has often been consistent with Black and brown people. We know this. But,
Insha, I apologize. I don't want to interrupt, but I know that Marvin actually has to jump off onto another meeting. I do want to come back to the public safety component, and especially these models that other states are using. But Marvin, before you leave, thank you, first of all, for joining us. And I want you to be able to just say a few final words.
Okay. Well, I just want to say thank you. And this has been a high bit of discussion for quite some time regarding the bail, cash bail, elimination of cash bail in its entirety. But just to wrap it up, to sum it up in my own words, the tone of bail reform was not about anything political. It was about creating fairness across the board for people who could not afford to pay bail, who had become the cogs in the machine, who were just being like I said, the commodity inside of a jail cell. Black and brown people who just could not afford their way out. The Harvey Weinsteins and the people of means were able to pay their bail and go their way, while the other people stayed and suffered, and their families suffered, and they lost their jobs and everything else. So it was really all about fairness, about being across the board, and making a safer environment for everyone. So I just want to say thank you, everyone. Thank you, all the panelists today. I appreciate your views, and I gotta go. Thanks.
Thank you, Marvin. The privilege is ours. Thank you very much for joining us.
Vidya, can I add something on supervised release?
Yes, you absolutely can, Nitin. And then I want to circle back, because I think that idea of public safety really is important for everyone to address, and then talking about crime. But Nitin, please.
So for the longest time, prosecutors would ask for bail, and judges would set two forms of bail. And it was usually cash, or it was an insurance company bond, right? And so our office was approached in 2013 by the mayor's office. And they said, would you be willing to do a pilot in Manhattan involving supervised release, this third-party organization that will be responsible for trying to ensure a person's return to court? It's giving the judge some other option other than releasing someone and actually setting some kind of bail. And we said absolutely, because we had kind of learned from Vera that we had some issues with our bail disparities. So we wholeheartedly welcomed in the supervised release program, and it was a pilot in Manhattan from 2013 up until 2016. But we were constantly saying this is only for felonies. And it's not for violent felonies. Misdemeanors are not even allowed to be in the program. Why is this? We actually want supervised release for misdemeanors as well. And the answers we got back from the city at the time was, these are very expensive programs. They're unfunded, right? So although they serve a really great purpose, who's going to pay the multi-millions of dollars it costs to do this? So we actually took $14 million out of our asset forfeiture money, and we actually paid for supervised release for misdemeanors and for felonies in every single county, not just in Manhattan. So we started that in 2016, in March of 2016. Since then, we have in Manhattan had 5,768 people participate in supervised release. 3,600 of them were for felonies. 2,168 were for misdemeanors. These are all people that could have gone to jail, but for and had bail set, but for there being this other option out there, right? So we're all in favor of giving judges another option other than just setting bail on them. And so our latest commitment was last year to the city to fund $100 million towards supervised release services moving forward. So I think, we agree. I agree with what you said, Insha, that for low-level offenses, let's keep them out of jail, right? 100%. I mean, we're trying to stop prosecuting a lot of low-level offenses. We don't want them sitting in jail like they were years and years ago, right? But we need to find something for them so they don't just keep coming back.
Right. And Nitin, low-level offenses really, they're just one part of, the crimes that are being prosecuted. So there's really twofold here. There's an argument here that, crime in recent months in New York City has blown up, essentially, and that somehow it's a result of the failures of bail reform. And critics of bail reform point to what has been happening in New York City over recent months and said, this is exactly why we told you that bail reform would not work. And then the other half of it is sort of this idea that, New York City just represents a very narrow portion of New York State entirely. Bail reform has been embraced around the country, but how has bail reform sort of been reflected, and does it really respect the idea of public safety and the safety of community members? So, Insha, I want you to start the conversation on that, and then Hemangi, this is something I know that we have discussed, and, I think from a defense perspective, it's also very important. So if the two of you could just chime into that a little bit.
Sure. I'll just start by saying this. So I was saying, we had actually championed a different version of bail reform in 2019, but when it passed, we decided as an organization, look, we want 4 things from a bail reform law. One is to use money bail far less if we can't eliminate it entirely, because money shouldn't determine whether somebody stays in jail or is released. The second is to make sure that there are fewer people in jail. We know we over-incarcerate, and the risk of over-incarcerating to people and their families is great. The third is to make sure that any kind of bail reform actually impacts racial disparities, which was our fundamental problem with New Jersey and the way that they did bail reform. And the fourth thing is that bail reform doesn't impact or doesn't negatively affect public safety. And what we saw, and we started tracking literally the day the new law went into effect, to see what happened on those 4 measures. And what we saw is New York State's overall jail population declined by 1/2. In New York City, it was closer to about 25%, now down to 30% of what it was a year ago. We know that the use of money bail has declined dramatically because judges can only set bail now on qualifying offenses, which is about 15% of all arrests, far fewer than before. Third, we know that racial disparities have gone down, not so much in New York City, but certainly across upstate New York, where, again, we're looking at jail populations, looking at who's behind bars and comparing from before bail reform to now. And we also looked and took on the question about crime and public safety. And here's what we found is, in January 2020, Police Commissioner Dermot Shea said, look, there's an uptick in certain kinds of offenses, and this is because of bail reform, because we're releasing people who otherwise would have been in jail. And so we looked at the NYPD statistics, and we actually went back 3 years, and what we saw is that 17% uptick in January from January of the previous year. That was actually not an anomaly. That was not terribly high. Usually the fluctuation from month to month in crime statistics in New York City is sometimes it's up about 25-30%. Sometimes it's down 25-30%. 17% uptick was not something to write home about, and it would have gone unnoticed but for the political backdrop of bail reform. And we saw that happen January, February, March, and that's really what led to the legislature saying, well, we have not a problem of substance of how the law is working, but a problem of politics that we have to respond to. And that was really the driver behind the rollbacks and the changes to bail reform that got passed in April of this year and that went into effect in July. And it's not only in New York City. We actually looked at arrest rates and crimes across New York State, in Buffalo, in Albany, wherever we could get the data to look again in real time. And what we actually saw in places like Long Island, arrests and crime were down as a result, in January, February, March. So it's the point is simply, it's the political sort of problem of saying we're going to use incarceration less. Fundamentally, people don't believe that we can use incarceration less and still be as safe. Even though the history of New York City, we've come down from 22,000 people behind bars in the early 1990s to now less than 4,000 people. And we're safer now than we were in 1992, where we had 3,000 homicides a year. And now we have about 300. We're a safer city, and yet people still don't fundamentally believe that we can have fewer people behind bars and remain just as safe. So that's fundamentally the challenge, the political and the sort of perception challenge that we grapple with when we pass reform.
And if I can just echo some of that, I mean, I agree that incarceration does not equate to public safety. And I think a lot of what we do and these conversations around charges and what charges require bail, if the conversation would shift to what are the underlying causes that bring people to the criminal justice system and how can we resource those areas and how can we address those areas, we cannot. The number of clients that I see who have untreated mental health issues, untreated trauma from the things that they've experienced in their incredibly overcrowded, overpopulated, under-resourced communities, right? If we could get at that and address that, they would likely not come into the criminal justice system, right? But we're focused on holding them, on keeping them, on separating them from our society because they're violent or they make our public unsafe. When really our conversation should be focused on what can we provide to the communities, what can we provide to individuals to keep them out of the criminal justice system? This is why I think supervised release is incredibly helpful to many of our clients because like Insha mentioned, it not only gives them a reminder for court, but supervised release can connect our clients oftentimes with services that they need, with housing, with jobs, with all of the resources that if our clients had them at their fingertips, I don't believe that they would be involved in the criminal justice system. I want to just speak about the rollbacks and the incredible fear mongering that happened at the beginning of this year. I know, I believe the NYPD recently released, if I'm not mistaken, they admitted that the increase in shootings was not related to bail reform and that their data actually specifically does not support any argument that the increase in shootings in New York City is related to bail reform. And there is no data to date that says that people who were released in January are the reason why we have more crime right now. There is no data to support that. And in fact, what we've learned is that there have been significant decreases in other crimes like robberies, rapes, but we're not associating that with bail reform and the fact that we're now providing people with services and keeping them from coming back into the criminal justice system. Instead, we are equating the increase in crime or what we think is an uptick in crime. But as Insha mentioned, it's not. It's just would have gone unnoticed had it not been within this political backdrop, right? I also think, and I would urge people to go to a website called Justice Not Fear, because the media tends to publicize these, put out these articles about these particular people who are rearrested, and it's because of bail reform. And justicenottfear.org is a website that debunks so many of these articles, that shows that these articles are not accurate, that it is not accurate that because of bail reform, we have an increase in crime. I think what we tend to do is I think we put too much on, we assume that bail is going to do more than it is actually intended to do. Bail is going to make us safer. Bail is going to avoid crime. Bail is going to, and that's not the purpose of bail. The purpose of bail is to ensure that someone comes back to court. You know, the qualifying offenses and adding offenses and adding the opportunity to set bail for someone. Again, it cuts against our presumption of innocence. A dangerousness argument cuts against the presumption of innocence. It assumes that a person who's standing in front of you is going to commit a future crime. And as Insha mentioned, we know that our country, that we criminalize and we arrest more Black and brown people. So that dangerousness piece, that moving to this remand status where you can decide that this person is going to be a harm in the future, that is done on the backs of Black and brown people, right? And Black and brown people have been saddled with all of these horrendous stereotypes that are in line with the stereotypes of a criminal. And so if we're gonna start using potentially risk assessment tools that we know are racist, if we're gonna start doing dangerousness arguments, if we're gonna leave it to judges who we've seen in the past have used their implicit biases to incarcerate people, I think it's a dangerous and a very slippery slope. So go ahead. I'm sorry.
No, okay. I didn't mean to interrupt you. I just wanted to add, Insha, correct me if I'm wrong, because I know you're an expert in this, but it is correct that New York State is the only state in the United States which does not allow dangerousness to be considered in setting securing orders. Is that right?
It is.
Okay. And I've given this a lot of thought for years, and I've been on all sides of it in my own head. And I've come down to the conclusion that we should include a dangerousness standard, recognizing, as you said, Hemangi, that it does fly in the face of the presumption of innocence, obviously, because people who are arrested are presumed to be innocent. And to the extent we're going to be incarcerating them before they're convicted of anything, obviously that's not consistent with the presumption of innocence. And I agree with you that, implicit bias is a subject we could spend the next few hours talking about, and I would love to do it. And I think, as a matter of fact, the court system needs to do much more in terms of at least training and making judges think more about implicit bias, because it really is a stunning field if you start reading about it and understanding how it really operates on people's minds. All of us, every one of us is subject to it. But on dangerousness, from the perspective of us as judges, we see offenders who are clearly dangerous in our view, who have committed terrible crimes and are at great risk to commit terrible crimes in the community. And we want to keep our community safe. It's just who we are, and it's something we want to do. And I think that there should be some ability within some very narrow confines to consider public safety risks. And as a matter of fact, if you don't let us consider it, which is the law now, it's seeping into our decisions anyway. Let's be honest. We're making discretionary decisions based on all these factors for defendants. And even if we're not sitting there saying to ourselves, you know what, I think this guy will probably come back to court next month, but I think there's a fair chance he's going to, seriously assault someone. So I'll let him go with a release on recognizance, and I won't set a monetary bail, and I won't remand, because it's not really about dangerousness. For the purposes of this decision, it doesn't matter whether he's going to go out and kill somebody. It only matters whether he's coming back to court. But the reality is that all these decisions that we make, considering all these factors, a lot of times the public safety issue is very closely linked to the flight issue. And it's very hard to disentangle those things. And so I think it would be better to have some very strict standards about when we would consider public safety than pretending that it just doesn't exist and we're not going to think about it and it doesn't matter. And all we're thinking about is flight risks. That's sort of how I've come out to think about it in the end.
Can I add 2 points real quick on this?
Yeah.
Absolutely. Then go for it.
Yeah. So I think most prosecutors were very disappointed when the bail reform law came out, that it didn't include dangerousness or public safety, because that's what we want to focus on and not really return someone's ability to return to court. Right. So, but I think that the reforms that happened, the second set of reforms that happened in April, do include a little of that. And I don't know, Judge, if you mentioned it, but there is a part of the new bail reform that when you're out if you commit a crime, which is either a Class A misdemeanor or a felony, and that crime involved harm to identifiable person or property, and you've previously been released on your own recognizance or on non-monetary conditions of another case that was also a misdemeanor involving harm to an identifiable person or to property, then the judge can set bail on this new case, even though it's a non-qualified offense.
And that's a reflection of something that I mentioned before, which is, although the legislature has said they're not allowing public safety to come into these decisions, in fact, the statute they wrote has public safety front and center. It's front and center in terms of what offenses are qualifying offenses and what offenses are not qualifying offenses. It's also front and center in the new non-monetary conditions that were added as part of what we're calling the rollback. So it's a very interesting thing, because on the one hand, the legislature decided we're not going to have public safety as a criteria, but then they wrote a statute that has public safety all through it, implicitly. And it's a function of the tension that they had and the disputes they had among themselves. And for example, the Assembly was particularly opposed to a public safety standard. The governor and the Senate majority had, more of a receptivity to doing it to some degree. And there was a lot of debate and fight. And in the end, they didn't have it. But they're infusing this statute with public safety considerations throughout it.
I want to throw out something that's sort of provocative, but we've had this standard of failure to appear for, a couple hundred years. And I think it's a really fair question to ask. Is that a reason to actually deprive somebody of their liberty anymore? And my ideal bail system would not detain people, even if they were, quote unquote, high risk of failure to appear, if they pose no threat to another person's safety. But I think where we might depart is what offenses would even sort of allow for detention. Because in my worldview, it would be a tiny, tiny portion of offenses, maybe tinier certainly than when I was talking to the legislature and the governor's office when bail reform was getting worked out. The suggestion of it just felt like, nope, we want to have the net of offenses and charges for which either remand or bail could be considered was just much bigger than, frankly, I think it should be to actually deliver on public safety. And so it was a compromise, leaving in money bail. I think everybody who was part of that fight would say that was a compromise, and it was a compromise to make sure that we actually did reduce the number of people behind bars. Because if you look at bail in another way, which is, thinking about our legacy of people buying freedom, and that has roots in slavery and emancipation, bail funds have actually really sort of brought the issue of bail and bail reform on the map, because it's communities and nonprofits and people who are directly impacted who are buying their loved ones' freedom from jail by paying bail. So it's just a very complicated. Bail is one of those issues that feels very simple on its face, and you get a tiny bit below the surface and you realize the policy questions, the moral questions are just immense.
Vidya, can I mention something that Hemangi and Insha raised earlier? It's just about the politics involved with the new changes in the law.
Sure, Nitin. Absolutely. I just want to know it's 7:25, so I do want to give a chance for questions. There's a few questions that rolled in, but please.
Okay, so briefly, look, when you have any kind of new statute that goes into place, you have to evaluate it over a period of time. It's tough to look at data for 2 or 3 months and then try to predict whether this is a success or it's a failure. So I totally get that. And something that Judge Conviser mentioned earlier is that now we dealt with the crisis in the middle of this new statute going into effect, which is COVID-19, which has totally changed the landscape of what's happening out in our city, right? So you don't have as many people out. You don't have the courts opening. So there's a whole bunch of different variables. But one thing I do have to say, I can't make any kind of correlations between the new laws and crime, but it's important to add that robbery complaints in Manhattan have exploded ever since January 1st, 2020, up until COVID-19 started. So we have a 36.2% increase in robbery cases. We have a 33% increase in burglary complaints. And we have grand larceny has increased by 20%, and grand larceny of an auto has increased by 193%. And I have to mention that all of these crimes are non-bail eligible now. And this is compared to the same time last year, right? So last year you could ask for bail on these cases. This year you can no longer. Robbery, aided or burglary of a dwelling is no longer bail eligible. But we have seen these spikes in those crimes compared to last year. I don't know if those spikes are going to remain. We'd like to evaluate those over the next, 6 months to the next 1 year. But we have seen those types of staggering increases, even post-COVID-19 year to date. Burglary complaints are up 114%. Grand larceny auto is up 55%. Grand larceny is down 53%, and that's probably because most of the stores are closed since the city shut down. So there are these statistics where we get the number of complaints that come in, and we have seen these explosions.
I just want to, Insha, I would love to hear from you because I know you love statistics. But I would like to just point out the first thing that Nitin said, which is that there's no data to support that it correlates to bail reform. And I understand that there are these stats in New York, but I don't think it's fair to in this panel to bring that up, because it almost just then creates this correlation that doesn't exist, that isn't supported by any data. There's no data to say that the people who were released on January 1st, who were charged with nonviolent felonies, are the people who are out there committing all these new burglaries and robberies and all of that. And what we saw was that after January 1st, the law was working. People who were released were showing up to court. They were going to supervised release. They were getting in touch with, they were getting connected to services. They were getting mental health treatment. They were getting housing. They were getting jobs. They were getting the resources that are required for us to be in a position where we can say that we are safe, that our public is safe.
Thanks, Hemangi. I know, Insha, you want to add a few words because you are the queen of statistics and you've been analyzing. So, but I do want to give a chance to be able to answer some questions here because obviously this is garnering a lot of interest. But Insha, go ahead.
Oh, I typed in the statistics because I think the point is you can't really look at short-run statistics and cherry pick from month to month. You do really have to look at crime trends at least over a couple of years to say anything meaningful about impact. So, Nitin, you're exactly right about the numbers, no doubt, but I don't think the correlation is there, certainly not causation.
Thanks, Insha. And I want to thank you all. I think the consensus between all of you is obviously that some sort of reform was necessary. How that reform is to be implemented in an effective way, still seems to be up for debate, and also something that needs to be seen over time as to what works, what doesn't work. One of the questions we had from one of the attendees, he asked, do you see a correlation between New York's resistance to total elimination of cash bail and moving to a New Jersey model with the fact that judges and DAs are elected in New York? I think Nitin and obviously Judge Conviser, I think, certainly I'd like to hear the two of you and what you have.
Well, I mean, first of all, many judges in New York are not elected. So, I'm not elected. The judges of the criminal court in New York City are not elected. Most of the judges, the vast majority of judges who sit in criminal parts in New York City are not elected. So I don't think it has to do with electoral politics vis-a-vis judges. I don't think it has anything to do with that. I think it has to do with the difficulty of making a radical change in the systems that we've had. I think as much as people wanted to reform bail, I think it was just too much to kind of envision a system that had no monetary bail at all. And it's also, and this is sort of a side point, but this is the kind of reform that would really be better developed through a study commission that took a long time and looked at it very carefully and developed a model that was drafted in a very careful way. As opposed to the normal way that legislation is enacted. I was a counsel to the state assembly for 13 years, so I wrote criminal justice laws. I know what goes on there. It tends to be people sitting in rooms late into the early morning hours, furiously negotiating and writing things and then passing them very quickly. And that's just the way the process works. But I think what would really be optimal would be for a commission to sit down and make a real thorough study and write a very careful statute that changed our whole system. But I don't think it has anything to do with the politics of electing judges, though. No.
I agree with the judge. I don't think it's about politics either. I just think that, they need to the legislature needs to take time before they, enact the law and then allow people to weigh in on it and reach out to all the different stakeholders, have public hearings on it so everyone can kind of, state their piece before it's actually passed.
Okay, thank you, Nitin, and thank you, Judge. Another question we have is, it's commenting on one of the things you had said, Hemangi, but it's directed really, I think, toward the other panelists. Ms. Pai said that supervised release is working. Do any of the panelists have the statistics that support this statement, especially since the reform was in effect for only 3 months and 1 week before the court slowed down due to COVID-19? I think hand in hand with that discussion is the idea of whether supervised release is working, but also how are in situations where people are released and they fail to return to court, is that situation sort of being addressed properly?
I don't have the statistics offhand, but because we're so involved with supervised release ever since 2016, we would attend these, quarterly meetings. And I remember that the recidivism rates were very low and for supervised release. So it was found to be working very successfully up until, this past year. I mean, in our office, we've had almost 6,000 people go through the program, and the recidivism and I think we've had the safest, the statistics in New York City have been the safest they've been in decades.
And Hemangi, is that your experience also with supervised release? I mean, obviously it is, but do you think that's where the focus really needs to be on terms of funding? That happens to be one of the questions.
Yeah, I do think that we should focus on supervised release. I also worry because I don't want supervised release to become the replacement for releasing somebody on their own recognizance, because net widening is not the answer, and making everybody participate in supervised release, I don't think is the answer either. I was actually just looking on my email because we did receive a scorecard from supervised release with the numbers, but I don't have it on hand. There was something that was sent to us in, I believe, March that indicated how many people were on supervised release and doing well. And so that's the place where I was speaking from, is that I do believe that, one of the things is with supervised release, someone is placed on supervised release and they're not following up as a condition of their release, they are reported to the court. Right. And so that information, if they pick up a new case, if they're not participating, the court is made aware of that lack of participation. And the reason why I worry about net widening is because not everybody needs a reminder. Not everybody needs to be involved in some sort of services, right? Not everyone needs that. And that should be left for people who need it, right? Not so that we are now asking people who are involved in the criminal justice system to have yet another piece of the government in their lives, right? That's my fear with net widening.
Okay, can I just give one perspective from a completely different place? I have a case involving corruption in the tow truck industry. On the first day that the defendants were arraigned prior to bail reform, they came in with agreed upon bail packages of, for example, $1 million. Okay, when bail reform came, I said, okay, I'm going to give you back your $1 million bonds and just report to supervised release. And what these defendants said to me is, I'd rather keep my bail. I don't want to go to supervised release. I'd rather keep my $1 million of bail. I already paid the bail bond company. It's already set up. Just, leave me alone. I like bail. So.
Only people all had that luxury going through the criminal system.
I mean, it's a different.
I was a public defender for years.
That's right.
I often think about this. If we actually set bail at amounts people could make, we'd set bail at $17.50. We'd set bail at it's totally arbitrary, and that's part of the challenge of this.
Yeah.
Insha, there's actually a question directed at you. The misdemeanors that constitute qualifying offenses are certainly infused with public safety considerations, as Judge Conviser had mentioned. But they are also quite arbitrary. Criminal contempt in the second degree is only qualifying if it is a domestic violence case. Domestic violence cases, as well as criminal obstruction of breathing, is a qualified DV. Is qualifying, but DV assault in the third degree is not. This makes no sense to both practitioners and victims. Is the Vera Institute addressing these problems and recommending further reform to the bail reform? And Insha, actually, before you answer this question, it's very nuanced and very technical, and I'm assuming it's coming from an attorney that is also practices criminal law. Judge, one of the other things that were asked were what were the substantive reforms. I'd ask that if one of you could just type in, online resources where the substantive law could be found. Obviously, as the DA's office, the defense attorney, and then also the defender's offices, as well as the court system, they all have their internal sort of resources. But if any of you have resources you can point to, that would be helpful. But Insha.
Yeah. So, at the heart of this question is how do we make this system less arbitrary? And the truth is arbitrariness is rife across all of this system. And the only way to have consistency is if we release everybody or we detain everybody. short of those two things, which we are not doing in our system, we make decisions and we draw lines that ultimately do feel sort of arbitrary. And that was the law that got passed, and that were certainly the rollbacks that got passed as well. And so our position, as I said, was, look, when the law was passed in 2019, it isn't the formulation we would have advocated for. It wasn't the version that we advocated for. But that being said, we know that bail reform is working. And so very clearly from the top of the year, we said we don't actually need any changes or rollbacks to this law. And at the very least, what we should do to be responsible is to actually wait a full year and study the impact of the new law as it took effect before we decide to tinker some more and make changes and make pretty drastic changes. So our work on bail reform, what I and my colleagues do is we work a lot with the Office of Court Administration and judges to make sure that bail is being implemented properly. In addition, for cases that are still bail eligible, judges are now required to consider financial hardship in setting bail and a person's ability to pay. And so we do a lot of work around that to make the use of bail, given that it's arbitrary that it still exists, but it does in our bail law, to make the use of it more equitable. So those are the reforms that we are pushing for. It's implementation. We actually don't think the rollback should have gone into effect. And if we're pushing it all for reforms, it's actually to go back to at least where we were at the top of the year, because at least in our view and from our research, bail reform was working.
Well, I think, though, that I don't disagree with the fact that you need to look at what happens before you decide on how to change it. But if your measure of whether bail reform is working is that the number of people incarcerated is being reduced, then yes, bail reform is working in that sense. I don't think it's working in terms of giving guidelines to judges that are optimal in terms of the decisions we make. So I don't, because it just doesn't, for us, in looking at all the things we want to look at and setting securing orders, some of these arbitrary rules just don't make a lot of sense to us. And the other thing about the statute, and we didn't really discuss this, and maybe this is a little bit too inside baseball for judges, is that the statute left so many major questions unanswered for us, just basic questions. What happens after a defendant's convicted? Do these rules still apply? What happens if you want to send the defendant for a psychiatric examination? Can you remand the defendant if it's not a qualifying offense? I could go through 8 or 10 of these major things that the statute just is not clear about. And so one of the things we've been doing is struggling and continuing to struggle over how to interpret a lot of these provisions. And it's going to result in years of disputes and case law over provisions that could have been written much more clearly. And that's not really the heart of what the issue is about. But it's a very difficult statute to work with because of all the ambiguities that are contained in it.
Okay. And I'll say this, because bail is so complicated. In DC, they passed bail reform in 1992. They're still litigating aspects of the bail law, and New Jersey certainly has had lots of litigation. So I've never seen a place where bail reform has gone into effect where there hasn't been ambiguity, confusion, litigation, all of those things. We could have spent 5 years writing this statute and we'd still come up with things that are not clear in all of the ways that you described, Judge.
Yeah, and the only thing I would say is that having written statutes for 20 years, this is what I did for 20 years, that this statute has an inordinate number of ambiguities. Even among statutes that address issues this complex, this particular statute has a great number of ambiguities and is resulting and will continue to result in much more litigation than would have taken place had it been written more clearly.
Judge, thank you. There's one last question. We are way over time, but I think it's a productive discussion, so I'm just going to shoot it out there. Judge Conviser, what are your thoughts about judges being required to produce a statistic report on factors related to race, gender, education, etc. when they set bail?
Yeah, one of the things, we didn't talk about this, but one of the things that the statute requires is an examination down to the level of the judge about the individual characteristics of every defendant for which securing orders are set, to kind of give you this picture of what the judges are doing. And I don't have any objection to it in principle. I think one of the problems is going to be that OCA doesn't actually collect this data now, so I don't know how they're going to do it practically. But the other thing, I think, if you're going to start looking at judges and saying that they're exercising their discretion in a discriminatory way, you're going to have to look at how each case compares in terms of the factors you look at in terms of securing orders, right? So that's I think something that's going to have to be part of the analysis. But no, as a principle, I don't think there's anything wrong with transparency. I mean, I think the more you can be transparent about what we're doing, the better off we all are. So, in principle, no, I think it's a good thing. I mean, I don't know how it's all going to work, and I don't know how they're going to do it, but.
Thank you. Oh, okay. As long as you all are willing to stay here, I do have another question. They just started rolling in. So does the court system still use an algorithm based on national criminal data to determine whether or how much bail is set? And in Judge Conviser, that seems to be...
No, we don't.
Okay. All right, great. I want to thank you all for your time and for everybody that attended today's session. I think it was a healthy discussion. And, I think, you can all correct me if I'm wrong, obviously, but the consensus seems to be bail reform is a beast. It's necessary, but how it's going to be implemented in an effective way that protects everybody's interest, the public's interest, the defendant's interest. And it appears that from every angle, it's a work in progress. There's room for improvement. And it's just amazing to hear all of your perspectives, personally. And then also, I think the people that listened in, this is available at a future date once the recording is finalized. And so I think it's something we can all learn a lot from. So I want to thank you, Nitin, Judge, Insha, Hemangi. It's been an absolute pleasure and privilege.
Thank you. Thanks for having us.
Thanks, everyone.
Thank you so much for having us.